you to our June 18, 2015 public meeting. Can you hear me? Everybody?
Yes.
Which is taking place today in the Department of Buildings building at 280 Broadway, 3rd floor. We first turn to a vote on the minutes from the May 21st, 2015 public meeting. Are there corrections or comments to the meeting, to the minutes? Do I have a motion? Sorry. Do you have a motion to accept the minutes? Keith, thank you. Second, please. Ms. Sheldon, thank you.
Mr. Barrett.
Yes.
Chief.
Yes.
Secretary Fisher.
Yes.
Mr. Zilling.
Yes.
Mr. Tucker.
Yes.
Sheldon.
Yes.
6 in favor, 1 absent.
Thank you. Lanny Alexander, our Executive Director, will now give her report.
Good afternoon, everyone. Actually, good morning, everyone. Just wanted to tell you that, as you know, Althea Bender, one of our attorneys, left after the last meeting. She's moved to Massachusetts. We're very sad about that. However, we're very happy to tell you that we have hired another attorney who will be starting in the middle of July. Unlike our last hire, who took a year to get through all of the mechanisms of the bureaucracy, we've managed to do this quite quickly, and we thank OMB and DOB and everyone who was involved in the hire. Our registration renewal time has come. So far, we've received 32 registration renewals, totaling $68,500. We will be keeping you informed every month as to how we're doing with that. I sent you all statistics that gave you the building breakdown of all of the buildings in our jurisdiction, which is 324 buildings in January, down to 321 today. And I gave you the breakdown of how everything progressed, who came up in the categories, the milestone categories. So I'm not going to go through that. And we also gave you the information with regard to the hearings. As you can see from the case statistics that we gave you in this little box here, we peaked with the number of cases pending in 2014, and we're now on a downward spiral of pending cases. So that's a good thing. And our total of applications, coverage applications, is now down to 194. So that's also a good thing. Do you have any questions from me? Because that's my report. No questions. Excellent.
Thank you, Ms. Alexander. We now come to the reconsideration and appeal cases. We have one appeal and one reconsideration case. The first case is an appeal of an Executive Director Administrative Determination, J.M. Hoyt, LLC, 32-40 Hoyt Street, Brooklyn, AD 0073. Ms. Cruz, would you please present this case?
Good morning, board members. On February 12, 2015, the Executive Director issued an administrative determination denying the owner of 32-40 Hoyt Street in Brooklyn an extension of the code compliance deadline for obtaining a final certificate of occupancy. On April 2nd of 2015, the owner filed this appeal seeking review of the determination. Loft Board Rules 107.1 and 201 require that an administrative appeal of a determination in an extension case be filed within 45 days of the date of the mailing of the determination. The staff mailed the determination on February 12th, 2015. Therefore, the deadline to file the appeal was March 30th. Here, the owner filed the appeal on April 2nd. The staff recommends that the board deny the owner's appeal as untimely.
Does anyone have comments or questions about this case, Mr. Lane?
I just have one question. The summary states that the owner filed the original application on July 2nd, 2012. And it apparently 2 3/4 years later, we denied the request for an extension. Is there a reason for that?
I just wanted to know about, it was like 1 or 2 days outside the period for submittal. Did they get back to you at all in regards to why they were going to put in the application, why they put it in like 1 or 2 days late? I just don't understand.
Why they would be late?
Just like by a day or two.
Well, a day is late.
I understand.
It's, you know, the statute of limitations is what it is. It's the date certain by which you must do something. 1 day later is not good enough in any kind of legal case where there's a statute of limitations. It is what it is. With regard to your question, Mr. Delaney, all of the extension applications were being delayed for various reasons. One reason was our workload. The second reason was what the legislature was going to do with the deadlines in the 2013 amendment and what they were going to do next with regard to these amendments. So we were lagging on that. But other than that, there was no reason. They were all delayed.
I just, in fairness to owners, if one's saying, I need some more time to get this done, it seems like a lapse of 2+ years before getting a response is, would cause me to scratch my head if I didn't.
Why would you scratch your head, Mr. Delaney? What would be the problem for the owner if the extension application response is delayed? What happens?
Well, first off, there are compliance issues with regard to the tenants, but I just would like...
That's right. So they're not, so first of all, they're not in compliance with the milestone, right? So what happens? The tenant's going to withhold the rent, right?
Right.
Okay. But if we grant the application X amount of months later, then, and it's retroactive, do the tenants then have to pay that rent?
Good question.
See, there's a good question. Then the second thing is, the other issue for the owner, not the tenant, the owner is, I'm out of compliance, the Loft Board is going to go against me for failing to comply with the deadlines, right? They'll bring an action, what we call DD action.
Right.
But we weren't doing those because we knew why they were out of compliance. Many of these buildings were out of compliance by the virtue of the fact that they didn't come into the Loft Board within a certain amount of time. Some of them were out of compliance the day they came in. So, you know, this was a very sticky thing. So we had a problem with it.
Is the problem more in this particular case with the technicalities of reading the law, or is it more administratively the agency, the Loft Board being
Too busy?
too busy?
No, it had to do with administrative, not the administrative issue. It had to do with the concept of what these deadlines were, what they meant, what we were going to do with them, how were we going to interpret the legislative intent when you see that the legislature creates days certain, shortens it in the 2013 amendment by 6 months for the 2010 buildings. Now, what are we supposed to do with regard to extensions? First of all, most of them are time-barred because they filed them too late. They would file them too late no matter what if they had just come into our jurisdiction. And if we are going to say, but we're going to give you the extension, then in fact we're not following what the legislature is telling us to do. If they're not going to move the deadline, then we are all between a rock and a hard place, and we have to follow what the legislature says. trying to give the legislature an opportunity to change the deadlines. Maybe they will.
So what's his penalty?
Pardon me?
Did not get his extensions, or what happens next? Has to pay a fine?
No, not unless, we're not going to go after people at this point for failing to comply with the deadlines. That doesn't mean that the tenants can't, and the tenants have. We had a case recently on West 45th Street where the tenants filed for failure to meet the compliance deadlines. And the owner was fined. It was an old building, however. It was one of the 28114 buildings. So we're not going after them right now for BVs.
Well, has he done the work?
I'm not sure where he is in the process.
They wanted an extension after 30 years and not doing anything. They're in the beginning.
They weren't going to get the extension anyway. Okay? They weren't going to get the extension.
Stay out of compliance, so we know.
What was the word of the tax?
It's a good way of getting out of the hole.
30 years.
The whole law.
32, 41.
And they hadn't done it in
30 years, and then they request an extension.
And what was their reason for it?
DOB takes forever.
Okay, so that's not enough of so we didn't grant it. We denied it. There's a reason. You have to show us that the delay is not your fault for any building, but in particular, since this is an older building, that the delay is not caused by you, and you're making every effort to meet compliance. And they didn't, and probably, although I'm not sure, because I don't remember right now, they were, the deadline had passed. And the deadline passed. So they were barred by the statute of limitations by that. Not statute of
The
limitations.
original extension was timed. We denied it because they didn't prove that it was beyond their control.
Okay?
Well, given the particulars, it would seem like the denial could have come
Earlier.
because there just doesn't seem to be a building that was caught up in the confusion.
I understand, but Mr. Delaney, the discussion here is whether they're time barred here. Okay? We know we didn't get to it right away. Okay? We got that. But this discussion is about whether this is a time bar and whether they have missed their deadline. Okay?
Yeah.
But I heard you.
Yeah, my question was not to attempt to try to justify the owner being late by 2 or 3 days compared to
Right.
the time it took us to.
I understand. We hear you, and I get it.
And I guess my underlying concern that I asked that noted in the record is given the current set of deadlines, is the extension process as we currently have it in practice and in our rules, is it burdensome for you folks to apply it, and should some thought be given to it? So yeah, I'm actually understanding.
And I appreciate that. You can't move. The compliance deadlines are not necessarily difficult for us to apply the way they are. They're difficult for everyone else to understand. We have a certain view on how they should be enforced and how they should be interpreted. There are many people who believe that the concept of 18 months, you have 18 months from the day you get your permit to achieve 7B compliance means that if I get my permit today, I have 18 months to do it. And that is not true. Okay? The 18 months from the permit date means the 18 months that the legislature deemed you should have had the permit in the first place. Okay? The outside date for that, not 2015, now I have a year and a half. So we have had many people come in and say, well, I have 18 months from, and say, no, that's wrong. So it's ambiguous the way it's written. We have it, we tell people it's been in our orders, our recent orders, what the timing is. I'm on your side in the fact that we think that it is difficult to have people who come into our jurisdiction already out of compliance. I think that should be reviewed by the legislature.
This is a, a quandary. So if they don't comply, you comply 2 days later, 3 days later, a month later, 2 months later. And there are no fines ever?
We used to do the BVs, the failure to comply with the compliance deadlines. We stopped doing them in about 2008, 2009, when we had done every single one we could, done every one we could, with regard to those people who were out of compliance with the old deadlines. The legislature kept moving the 70 and the C of O deadline, so nobody was ever out of compliance with those, because they kept moving them. Now, we don't do them because we are awaiting the legislature's determination on what the compliance deadlines will be. And then we'll start dealing with how we're going to interpret what they say.
Well, I mean, it creates another problem. So let's say the legislature does have at least the deadlines either in perpetuity or a kind of rolling deadline, in which case I don't really understand why and when a landlord would then comply. If there's no deadline, then, well, I could do it next year or the year after, providing the legislature does have a timeline or a rolling timeline. But if it's done in perpetuity, which makes sense, right? It's these spaces come into compliance at any time during the next 150 years or whatever. I can understand that. But then it creates a sort of...
Well, we're not saying that we're not going to do, there are other, not only can we do the failure to comply with our deadlines actions, but we also have an even better tool, which is the reasonable and necessary action. The reason that we passed that, you all remember what that is? If you are not taking, there was at one time only one rule. If you fail to comply with the deadline, you could be fined $1,000 per violation. It was not particularly persuasive for any owner, so they pay a couple of $1,000. They didn't care. So and the legislature kept moving those last 2 deadlines. So we had a problem with that. So we passed a rule that said, if you are not taking reasonable and necessary steps to reach these deadlines, we're going to fine you. We're going to go after you. So those people, like a building that's been in our jurisdiction for 30 years and doesn't have a permit that's active, that's, you're not taking reasonable and necessary steps. We can go after you with that. And we will do that. But not right now.
So we voted on those rules.
A long time ago.
Oh, that was a long time.
In 2008.
Well, perhaps, I'm sorry.
Go ahead. No, I think I was here in 2008.
Yeah.
Perhaps working on the assumption that at some point this month the legislature adjourns for the year. Maybe in the July meeting or the September meeting, we could really take a look at some of the points of confusion that maybe the board should think about either addressing through public education so that owners who think, oh, I get 18 months from today rather than 18 months from back then could find that out in a kind of programmatic way. I notice we have a case coming up, number 3 on the docket today, where we note in the order that owners are supposed to file 28612 sales. And so that's another point that might be something to kind of, particularly since we always have both new owners purchasing buildings under the original law and many new owners brought in under the 2010 extension.
I think that's an excellent idea.
And at the same time, maybe we should take a look at some of our rules to make sure that they make sense. I'm thinking of, for example, the requirement for a monthly report, which, last time we discussed it some time ago, I don't think that's necessarily happening in every building all the time. We might want to just try and come up with a more workable scheme once the danger of the legislature changing our circumstances is done for, in all likelihood, for 2015.
So could you, what do we propose to the legislature in terms of these deadlines or new timelines? I forget what he wants to sort of respond. What did we ask the law department to send before?
Well, so we've made our position, I'm sorry, I didn't interrupt. So we made our position known to the folks at City Hall, and the position was pretty much step of what we discussed here in those last meetings, and that remains up in the air for the moment, I think is about all I can say. But we did express our position based on those conversations and that some of the last meetings.
We have nothing back to say that this will be submitted or not submitted, maybe not submitted.
In fact, the way the legislature had a proposed amendment, I don't know what's going to happen to it at all, I have no idea what's happening. But I can tell you that even in the proposed amendment, they are changing the date that you start counting from. In the previous law, I believe it was the effective date of the law, and now it's going to run more with the date of either the IMD registration date or the date of a coverage registration. It's going to be more, that's going to be a little confusing, and it'll be problematic for us, but it's going to run more in the proposed legislation. It's going to run from, not from the effective date of the law, but from the date of hopefully from the date we become an IMD.
You're alluding to a bill in the Assembly?
That's the Assembly bill, as it stands, as it stood 2 weeks ago. So, I mean, all I'm saying is they were cognizant of the issue, for which we were grateful, of knowing that the way it was before, on the effective date of the law, was the date that you started counting. That made it that all of these other new buildings, the 2013 buildings, and the buildings that were still pending at oath at the time, all come in out of compliance. So they did change the language and at least knew that that was a problem for us.
So, Lanny, is any of this information on the Q&A, but on the website that you have to let the public know about these code compliance deadlines?
The code compliance deadlines are on the Q&A, and they're also on our website. But I think that you're right to, once the legislature does whatever they do, I think that what we will do is we will write something out to send to all of you to tell you what happened and our interpretation of it. And then we will certainly discuss it at the board meeting for the public and its ramifications and how we interpret it for them, as well as these other issues, these other topics. To get back to this now, does anybody want to move to accept this case, Ms. Shelton?
Second. Chief, thank you. Ms. Rivera, can you pull the numbers?
Mr. Barrett,
Yes.
Chief,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Chapman,
Yes.
Ms. Shelton,
Yes.
6 in favor, 1 absent.
Thank you. Next, we have a reconsideration case, which is Louisa Christian Wasserman, and Denise Langenegger, 357 Broadway, R0338. Ms. Cruz, could you please present this case?
This is a reconsideration reconsideration application seeking review of Loft Board Order 4350, which granted Article 7C coverage pursuant to 2815 to the units on the second, third, and fourth floors of 357 Bowery. In this order, the Loft Board also determined who were the protected occupants of the third and fourth floor units. The board found that Christian Wassman to be the only protected occupant of the third floor unit and denied Ms. Squee's claim for protected occupant status for the third floor unit. In this reconsideration application, the tenants argued that the Loft Board should construe broadly its rule in 209B1 to give the protected occupant status to any tenant who resided in the unit on the effective date of the law, and in failing to do so, the Loft Board also failed to follow its own precedent. The staff recommends that the reconsideration application be denied. According to 209B4 of the Loft Board rules, the prime lessee is deemed to be the residential occupant qualified for protection under Article 7C. The prime lessee can prove that the residential unit is his or her primary residence. The record in the coverage case showed that Mr. Wassman is the prime lessee and that he used the unit as his primary residence. Therefore, Mr. Wassman is the occupant entitled to protection. Where there is a prime lessee like Mr. Wassman, it is that person who is the residential occupant entitled to protection. As explained in the proposed order before you today, it is the prime lessee who bears all legal responsibility for the unit, and it is the prime lessee who has the legal obligation to pay the rent. In this reconsideration application, the tenant cited Loft Board orders in support of the claim that the Loft Board departed from its precedent, denying Ms. Squee's claim for protected occupant status. While two of the cases cited by the tenants are factually similar, the staff does not recommend that the board follow the analysis used in matter of Lagman and matter of Van Du. In both of these cases, the Loft Board found the protected occupant based on large part on the theory of succession rights. However, the claims of protected occupant in these cases are not based on the departure of the prime lessee. Therefore, applying the succession right analysis to these facts was not appropriate. The analysis did not apply in these cases and does not apply in the case before. Mr. Wassman still occupies the unit. Ms. Squee is not a family member seeking to remain in the unit after the prime lessee vacated. In matter of camera malice is another case cited by the tenants in this reconsideration application. However, the outcome in this order actually supports the determination to deny Ms. Squee's claim for protected occupant. In matter of camera malice, the Loft Board denied his son's protected occupant claim of his mother's unit. The board found that Ms. Cameron Malice was the sole prime lessee and was in possession. Therefore, her son could not be the protected occupant at that time. In the order, the board found that the son only had the potential of succession claim while she still occupied the unit. This is exactly what the board found in Loft Board Order 4350. The staff recommends that the board deny the reconsideration application.
Thank you. Comments, questions? Mr. Delaney?
I'm going to vote against this case. I think that our analysis that we made prior decisions that we're now treating as wrong is incorrect. This is the same issue that we discussed at the meeting last month. And as I recall, there was some sentiment among board members to try to have a discussion of this issue independent of being in the midst of a case. But obviously, that was not on this month's agenda. And unless you object, I would ask that it be considered for the July agenda, because I think everything we're doing here is wrong. As I wrote in the dissenting opinion I filed, as regards this case when it was on the January docket, as I wrote in the opinion I wrote last month, in my view, invoking 209 is only in the instance where there's a dispute over who has the right to occupy between a prime tenant and a subtenant, and a prime tenant and a subtenant is subdivided space, a subtenant who was in the unit during the window period while someone else held the lease. And we go about, in this case, taking upon ourselves the responsibility, contrary to the other judge, who found Ms. Bowie to be a protected occupant. We have come to the opinion that we need to deem who is a protected occupant. I think the act of deeming really only comes up when there's a dispute. In this case, the people are living together. Trying to tease the succession rights in Rashi under rent stabilization and apply that to the Loft law, to me, is an apple and orange comparison, because there's no window period in rent stabilization. So that, to me, while in the reconsideration order, it's described that, I won't waste time looking for the exact, but the ridiculous conclusion that everyone who occupied the unit during the window period is a protected occupant. To my recollection, that's exactly the way the Loft law has been applied through the years. And I think there are many more cases other than the ones here that are described as mistakes. I think this is a mistake. And again, talking about inconsistency, here in our analysis we point out that at various times we found the child who occupied the unit during the window period to be a protected occupant. Last month we found the opposite to be the case. We're just all over the place on this. And I think deciding this on cases where, in this, there are numerous cases cited by both the Loft board and by the attorney filing the reconsideration application, having these come to the members on a Friday afternoon, and I've written to both the acting chairperson and the executive director that I think we should have a couple of weeks to look at some of these complicated cases. I think we're wrong on this issue.
Did they cite you? Yeah, they only cited 4 cases.
There are other cases on the docket. There's a lot of reasons.
I see, but in this particular case, you got all of the cases that.
Yeah.
Okay, I just want to make sure that all of the cases that were cited that you received. With regard to your suggestion that 209 only applies to the contest between a prime lessee and a sublessee, I would say that that's incorrect. First of all, you can't determine a sublessee's rights unless you know who the prime lessee is, or who the protected, at least who the protected occupant is. And in 209, and you referred to this, by the way, I watched the video several times since I was absent. And you referred to the first set of rules. And in the first set of rules, where they talk about where this is in, and yes, it says coverage, and then it has parentheses, and it says subletting. And then A is definitions: privacy, privity, tenant. B is occupant qualified for possession or residential unit and protection of Article 7C. That's what it says. That's what all of that portion that we're talking about, 1 through 4, comes under that subheading. That is about who the protected occupant is. How do we determine who the protected occupant is? And also, you alluded to a case, and do you remember the name of that case? Where there was a prime lessee and a sublessee, even though it's not on point. Do you remember the name of that case?
I'm sorry, which case are you
You were talking about a case where the prime lessee had been out of possession and was getting the. Is that just Bishar?
No.
No?
No, it's, refresh my memory.
Because it would be helpful when
Oh,
you do these things.
I don't know, but I can't remember.
That we can look at them to make sure that,
Yeah.
we can see what you're
I
talking
need to
about.
tell you what disturbs me about this. So Ms. E has 2 choices. Either she has to leave, or she just stays there, right?
Why would you have to leave?
Well, she's no longer a protected tenant, maybe she gets some information that she's living there illegally. but people are living illegally in lofts all over the city of New York. And we're unable to deal with a lot of it. I mean, there's a case coming up, with a sort of multiple dwelling unit in one loft space. So if she just continues to live there forever because, because those owners who let her live there. So I mean, I don't know what the difference is. And I understand that, she could be forced to leave, right? In which case, I'm not saying that we're throwing her out of that spot, but, essentially we are. And just looking at the greater picture of the city of New York, I mean, housing is really a complicated and a terrible situation. And we ought to try to provide as much housing for as many people as we possibly can. And, you write a law and then you find out that there's a glitch in it that we can't really decide. And I certainly don't have a solution to this, but I just try.
I understand that, you know what, the problem is sometimes when we follow our rules, we have a rule which we're asking you to follow. And what you said about the greater picture is absolutely correct. Because it's not just about Miss Week. Does anybody know how the correct pronunciation is? We've been calling her several different renditions of her name. Whatever her name is, I really apologize to her. Louise. The tenant at issue here, it's greater than just her because it comes up in all kinds of different renditions. And so we have to follow the rule. We have people who are husband and wife. We have people who are children. We have people who are significant others. We have people who live there and come and go. And there's one prime tenant, or maybe there's two. And so we are making this analysis for everyone. It pertains to everyone, each kind of situation. So when we say, and when Martha has been saying over and over again, this is what the rule says. If you have a prime lessee, that's the protected occupant. If the owner, just like with any rent stabilized lease or any lease, I have a lease in my name. I get married. I want to put that person on the lease. Can I go to the landlord and say, I'd like to put that person on the lease? And the landlord can say, okay, or no. But I have that ability to do that. In many cases, which you brought up last month, we accept the landlord's saying this person is a protected occupant, because it's really the contract between the landlord and tenant. It's the landlord's determination if he wants to make somebody a protected occupant. If he wants to make Ms. Hui a protected occupant, he can. All he has to do is register her as one. But when it comes to us trying to make that determination, we have to follow the rule. And just like the statute of limitations can seem harsh when you miss it by 1 day, so too does it seem harsh when the wife of the tenant, for example, there are people here whose wives are not protected occupants. They could go to the landlord and ask for that. Or not. I believe there are many people who've been living in units who are not the protected occupant, but are married to the protected occupant, and nobody's made that person leave. So I think that, we have to remember what we're doing here. And that is we are trying to be consistent. But just remember what, if you want us to be consistent with a wrongly decided opinion, that's following. Okay? If you look at the way Lagman was decided, you will see that they relied erroneously on the succession rights and said, oh, she lived with him for 20 years or whatever it was. She deserves it. That's not the legal criteria. Okay? That was an emotional determination. And we're trying to take that out. and say, we have a rule, let's follow the rule so that everybody is certain how they are treated under the law. And whether we like it or not, that's what we're doing.
I have to say, it's eloquent. I'm totally unpersuaded. Number one, again, following Brashy and rent stabilization, where there's no window period, is different. The example you gave, I'm covered, I get married later after the window period, is not the fact that we butted up against last month, where a family moved into the unit, already married. The landlord executed a lease only with the husband. We found the husband to be the prime tenant and said the wife and child might have succession.
Mr. Delaney, why did the owner and the tenant enter into a lease where only the husband was the lessee?
I have no idea.
That's right, and I don't either. But that couple should have been more careful. And you know, I can't be there for everybody and say, you know guys, you're in trouble if you don't both go on the lease. There are people who are not married. There are people who are roommates. They all go on the lease. They all are responsible. They all are protected. That's why you have them.
Actually, the reason the window period was established by the legislature is because of the sham nature of many leases, where people said they weren't going to use the loft for living purposes. They said they lived with their parents in Vermont. They said all kinds of things. In my opinion, the test is presence during the window period of 3 or more families living independently. And the presence of 2 people who are married, where the landlord only executed a lease with one of them, has no bearing. And obviously, look, we can discuss this all day long. This is going to go to an Article 78. The courts will look at whether or not it's being arbitrary and capricious. But certainly, under any interpretation, if we think a bunch of cases we decided were wrong, we owe it to the public to look at a rule and to conduct a public hearing rather than change our position.
We're not changing our position. Pepe Malice was clear. It supports us completely. The Chamber Malice case. She was the prime lessee. She was the one who was determined to be the protected occupant. The son was the protected occupant of the other unit because his father was no longer there. His father was no longer in possession. So he became the protected occupant. But he couldn't become the protected occupant where the prime lessee was still there. Okay? That is what our rule is saying. That is what we're saying. And Mr. Delaney, with all due respect, I never expected that I could persuade you. I'm not that eloquent. so I'm not disagreeing.
Good.
Okay? And I understand where you're coming from, but you have to understand that we're trying to respect what the rules say.
Thus far, you don't seem to have been able to persuade the judges at oath either.
Well, actually, that's not true. Because
based on what's come to us.
Yes, but in what's coming down to you soon would be cases where the oath judges are looking at what we're doing and now they are following that. And it has clarified for them something that has been murky for them in the past. Because we seem to be, as you have said, all over the place. Let's try not to be all over the place. Let's try to get it right and get it, down. One way or the other, Mr. Delaney. And you're right. In Article 78, it would be a fine thing. I have no problem with that.
Anyone else? Is there a motion to accept this? Shelton, thank you. Do I have a second? Anybody?
We'll table it until we have a full board. And Ms. Alderman Rivera comes back.
All right, I'm going to table this matter for the next meeting. We turn now to the summary calendar. There are 11 summary cases. These cases are voted on as a group. They are Timothy Murray, 304 Worm Street, Brooklyn, PA 0198. Christian Gray and Matthew Tannen, 226 Franklin Street, Brooklyn, TR 1101. Tenants of 103 and 105 Bowery, 103 and 105 Bowery, TR 1104. Anja Bilbachi and Rasmus Bilbachi. Sorry, 224 Front Street, TR 1138. Nate Wood and Jesse Hume, 226 240 Franklin Street, Brooklyn, TR 1139. Jesse Selleck, 151 Kent Avenue, Brooklyn, TR 1186. John Natuzzi and Kyle Boyd, 151 Kent Avenue, Brooklyn, TR 1187. Nick Salerno, Pat Lukama, and Louis Rose, 226 Franklin Street, Brooklyn, TR 1209. Darren Pulley, Chris McInerney, George Bennett, and Jana Jane Chuskabaya. I got it wrong, I'm sure. 151 Kent Avenue, Brooklyn, TR 1225. Sean Savar, 151 Kent Avenue, Brooklyn, TR 1226. Tyler Wilkins and Jenna and Ernesto Aliza, 244 Front Street, TR 1247. Comments or questions on these cases?
I just want to point out to my colleagues that number 3, Timothy Murray, 304 Gorham Street, is the case where once again a tenant goes ahead, files a rent adjustment application, believing the unit to be a covered unit, and the landlord pulls out a 28612 document that had not been filed with the board, thereby wasting our time. If the tenant consulted an attorney, racking up legal fees, we have no way to force the owners, other than here where we say, failure by the owner to timely file a sales record may subject the owner to civil penalty. But of course, we're not doing it here. We've never done it.
Mr. Delaney, if I could just interrupt for 1 second, because I hear you loud and clear. And we started with this case by discussing in depth whether we should do this penalty in this particular case. We were leaning towards doing that, and indeed have written a draft where we had assessed the civil penalty. The problem with that was that the timing of things were a little problematic for us, because, let me see if I can remember the timing. The tenant came in to review the file where he would have supposedly seen the sale of rights had it been properly filed, right? That would have stopped him from asserting that he had some rent adjustment case. However, he came in, under normal circumstances, you have 30 days that you have to file your sale of rights with the Loft Board, otherwise you can be fined. But in this case, because it was
Yes, it's a 281 building. The way it worked out is that the rule is broken up by, you have to file within a certain time. If you're on 181 building, there's a certain date by when you have to file in your 284 building. And if you're in the recent amendments to the rules, we added another paragraph for the 285 buildings.
so that although the 30 days had passed, the time within which the owner, although the owner was indeed later than the time that was in our rule, the tenant came in before that time period. So the tenant made the determination too early. If he had at least waited until December, then he would have relied to his detriment on the fact that the owner had been recalcitrant in filing. But that is the reason that we didn't do it, okay? Because he was too early. We are waiting for one, and we will do it, believe me, as soon as we find one that's clean and clear and crystal clear.
It's exactly in this situation where we would impose a fine.
Right, and I understand here the window period for due diligence had not fully
Passed.
told.
And that's why we will do it.
Got it.
Any other questions or comments? Is there a motion? Yes, sorry.
I thought the case 103, 105 Bowery was very interesting in regards to allowing two buildings to be a single horizontal interval dwelling. And the reasoning behind it I thought was very good in regards to why that was allowed. And I was just wondering, is that going to be the case for any other type of approvals, like you have same owner, managed by the same company, the principals are the same, financed together under a single mortgage, restricted together under a single assessment of leases, heated through a single heating system, share common standpipe and sprinkler line lease connection, similar height, load-bearing wall that they share, that type of thing, same insurance policy. I thought that was very good in regards to the stipulation. I just want to know, moving forward, is that going to be used to make things?
Chief, are you asking if we would use similar criteria when determining if something's a horizontal multiple dwelling?
Yes.
Yes, we do that now, it's written in our rule. And that
Written.
really sort of is tracking what we do in our rule and what we've done in prior horizontal multiple dwelling cases.
Chief, I would just add for your edification that the reason the board wrote a rule on this was for the opposite circumstance, where owners said, oh, I've got two tenants at 47 Walker and I've got two tenants at 49 Walker, I'm going to split it into two buildings and
So
I'll
that they
be
can-
free of
yeah.
the loft law.
Usually it was done where there were two in one building, one in another, where they didn't have the three required tenancies.
That too.
I'm going to vote for this, but I must say that there were compelling arguments.
There was what?
There were compelling arguments by the attorney, the landlord, but nonetheless.
Well, I like it that you're allowing them to work separately to try to get approval based on those stipulations. So I thought that was good.
Okay. Anything else?
Is there a motion to accept the summary cases? Mr. Barrett, thank you. Do I have a second? Mr. Delaney, thank you. Ms. Rivera, can you poll the numbers?
Mr. Barber,
Yes.
Chief,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Shackman,
Yes.
Ms. Shelton,
Yes.
6 in favor, 1 absent.
Thank you. Motion passes. We now come to the master cases. We have 4 abandonment cases. I'm sorry. We have 1 abandonment case and 3 coverage cases, total of 4 cases. Please note that the 2 Baker Street cases have been combined into 1 order. The first master case is the abandonment case, 26 Bond Street Management LLC, 26 Bond Street, LB 0189. Ms. Cruz, would you please present the case?
On May 2nd of 2014, the owner of the building filed an application seeking an abandonment fine for Unit 2F based on the death of the protected occupant. The owner listed the executor of the tenant's estate on the application as an affected party. In the letter dated March 6, 2015, the executor informed the board that there were no successors to the unit and she did not wish to contest the application. In her report, Judge Globe recommended that the board grant the owner's application based on the tenant's death. Section 210 of the Loft Board Rules defines abandonment in part as the relinquishment of possession of an IMD unit by the death of an IMD tenant, provided no family members denied the benefits of succession rights under Section 208.1 of the Loft Board Rules. The record shows that the tenant died on April 4th of 2014 and no one asserted a claim of succession. Staff recommends that the board grant the application.
Thank you. Questions, comments?
Do we have a list of how many times this building has come before us? It's a statement, it's not a question.
Is there a motion to accept this case? Ms. Shelton, thank you. Do I have a second? Thank you. Ms. Rivera, sorry, Mr. Shacker, thank you.
Yes.
Chief,
Yes.
Chairperson Bishop,
Yes.
Mrs. Delaney,
Yes.
Mr. Chapman,
Yes.
Ms. Shelton.
Yes.
6 in favor, 1 absent.
Thank you. The next two cases are master dismissals and have been combined. They are Miranda Gandel Danish, Sydney Oakley, Bennett Schlesinger, Michael Berman and Tom Underwood, Ethan Gabriel Hunt, and Justin Burke, 239 Banger Street, Brooklyn, TR 1002 and TR 1004. Ms. Cruz, would you please present these cases?
On March 30th, 2012, the applicants of 4D, 4E, and 4G in 239 Banker Street in Brooklyn filed an application seeking coverage pursuant to 2815 and protected occupant status for their units. The law court docketed the application as TR 1002. On April 4th of 2012, the occupants of 4A also filed an application seeking lawful coverage. The law court docketed the application as TR 1004. On September 23rd of 2013, Judge Ordinary issued her report recommended that the applications be dismissed without prejudice pursuant to 1-06 of the law court rules due to the tenant's failure to appear for a hearing after due notice. Oath conducted several conferences for these applications, except for Ethan Hunt and Tom Underwood. None of the tenants ever appeared for any of the conferences. On July 3rd of 2013, Oath sent the tenants a notice of hearing scheduled for September 10th, 2013. None of the tenants appeared for the September 10th hearing. Based on the tenant's failure to appear, the staff recommends that the board dismiss the coverage applications docketed as TR 1002 and TR 1004.
Thank you. Does anyone have any comments or questions about these? Do I have a motion to accept these cases? Thank you. Do I have a second? Ms. Shelton, thank you. Ms. Rivera, can you poll the members?
Mr. Barrett,
Yes.
Chief,
Yes.
Chairperson Bishop,
Yes.
Mr. Delaney,
Yes.
Mr. Chapman,
Yes.
Ms. Shelton.
Yes.
6 in favor, 1 absent.
Thank you. Motion passes. Finally, the last case is also a coverage case. It is James Becker, Tommy May Nally, Jennifer Cosin, Edward Davis, Andrew Carbone, and Ryan Walters, 778 Bergen Street, Brooklyn, TR 1183. Ms. Cruz, would you please present this case?
On March 3rd of 2014, various tenants occupying the second floor of 778 Bergen Street in Brooklyn jointly filed an application seeking findings that their spaces on the second floor are IMD units pursuant to 2815, and that they are the protected occupants of their respective space. The owner failed to file an answer to the coverage application. Judge Addison denied the owner's motion to vacate its default as untimely. Judge Addison barred the owner from presenting a defense and participating in the hearing. In her report, Judge Addison recommended that the law court grant coverage to the spaces described as units A, B, and C. To reach this conclusion, Judge Addison relies on a line of cases that focus on whether there was sufficient indicia of residential use. However, the question here is not whether the spaces were residentially occupied. Rather, it's whether there is sufficient evidence to show that the tenants lived independently from one another. Loft Court Rule 208 provides factors for the board to consider in determining whether the units seeking coverage have attributes of independent living. The factors include having a separate entrance, providing direct access to the unit from the street or public area, and other indicia of independent use by the tenants. Also, Judge Addison found that each of the tenant spaces were accessed from a hallway. However, while the spaces each had an entrance door, access to the doors is not from a street or a public area. According to the floor plan, the spaces are accessed by a shared hallway that is part of the area used by the tenants. Also undermining the tenant's claim of independent use is how the second floor is described by the lessee and the sublease used by Mr. Becker himself. The lease with the owner describes the entire second floor as a private single-family residence with the provision that Mr. Becker was to have one mailbox key and 5 keys to the leased premises. The subleases entered into by Mr. Becker also describe the leased premises as the second floor rather than referring to a particular portion of the second floor. The spaces were not rented individually. Mr. Becker and the other tenants' control over who occupied the other spaces on the second floor also undermined the tenant's position that the units were occupied independently. Mr. Becker testified that each of the subleases contained a 30-day termination clause so that the people could leave without penalty, or if the tenants wanted another tenant out, the tenant could ask them to leave. Mr. Becker referred to it as a community culture. Taken together, the facts in this case do not support finding that the tenants lived independently. The lease describes the second floor as one unit. The subleases do not identify the specific spaces on the second floor as sub-units. Access to the space is not by way of a public hallway. The tenants share the bath area, the toilets, and the kitchen. The community culture referred to in Mr. Becker's testimony illustrates the control the other tenants would exercise over the entire second floor, not just their own space. The staff recommends that the application for coverage for the spaces identified as units A, B, and C, and the claims for protected occupant status be denied.
Thank you. Comments or questions on this?
Didn't we used to call it SROs?
What would you say?
We used to call it SROs.
Yeah, I mean, this is what I described once as like an Indian longhouse. And there are many spaces in Brooklyn like that. You know, where it's like a dormitory. Bedroom, 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 maybe one kitchen, maybe two, maybe one bathroom, maybe two. You know, 6 people living in a space that's quite habitable in some ways.
Well, I think it's important, just having quite some time ago lived in an SRO building, they generally don't have large common areas, so I don't think
This one has one, besides the corridor,
did you look at the
clearly not corridor.
floor plan? There's a copious, gigantic common area, including performance equipment, religious statuary, not stuff I ever saw on the SRO. I live in the Brooklyn, the west side, so I don't know.
Just one.
Yes.
Yeah, it's a suite.
And were there 3 such suites in the building? Would one consider this
For me, that's a different, those are, at least the way my gut reaction is, it's kind of apples and oranges. These are not individual apartments. This is not an apartment. Nobody has a full apartment. It's not a multi-family apartment complex. It's, it would fall under a different kind of categorization because nobody has their own bathroom, let alone a kitchen. So, however one feels about it, that's just, they're not real, they're not what I think we categorize in New York and certainly nationally as an apartment. I mean, you can call it a kibbutz or whatever.
Well, I wouldn't call it that or an SRO. It is a close enough call that obviously the oath judge made a determination in one direction that we're reversing. And Ms. Cruz, could you just reiterate why you rejected the oath judge's finding in this case?
The way the unit is, or the spaces are described in the leases, like on the master lease with the tenant, Mr. Becker and the owner, as one single family dwelling. The way the spaces were, or the lack of the description of the spaces in the subleases were Mr. Becker. So Mr. Becker leased the space on the second floor, but didn't specify the way he's trying to do here. In this case, it's unit A, unit B, and unit C. The other things, the community culture also is troubling because how is it, you don't have control over your neighbors being able to occupy space. You can't go to your landlord and say, I want you to evict this person. It's sounded like the tenants themselves sort of voted someone out and the person had to leave. By Mr. Becker's own testimony.
I think the more, my comment more was the SRO is more about the safety thing, because I know if they have an apartment, it's a one-person apartment, or one family, you can't have 3 kids in there, or whatever, or multiples, because it's not safe. That's what we're doing.
With the SROs, there are rules and regulations regarding sprinkler heads have to be in each individual room, so that would have to be changed if they want spaced accordingly. These people are living separately in SROs. SROs are pull boxes, alarms, go to a central station in case there's a fire. So an SRO has certain safety requirements. There also SROs require like a safety coordinator on the premise to make sure everything is proper in regards to housekeeping, fire safety, that kind of thing. Also, Martha, did you read about the egress, not going out to a street? Did you read something like that in
Yes.
regards to the exit, the egress, it doesn't go out to a street? Where does it go?
Well, the floor plan shows, it's part of your backup, actually, in front of me, but the floor plan shows you coming onto the second floor and there being a closet there. Directly in front was this huge living area where I believe the description was that they had a piano, they had a Buddha, they had a kitchen table, I believe, or some other things in there, all like personal items. And then there was a bathing area where people could shower, I guess, and then a set of toilets, and then a kitchen area, and then that was like the common area. And then you keep walking and you go through another set of doors, and that's where you access the actual doors that go into the units A, B, and C, the places described as A, B, and C. So you go onto the second floor, there's a hallway, there's a living area, there's the bathroom and the toilets and the kitchen, and then you go through another set of doors, and then you go to the area where you can actually access the
So those doors, that
entrance doors.
hallway is an internal hallway within the unit. It is not a public hallway that's accessible for anybody who wanted to come into the building.
Right, but if you're in room A, B, or C, you have to go through B and C? to
No,
get to
again,
your
you go
room?
out to the hall, you go out your door into that long hallway, and then you can go back into the common area.
So you go out, you get the hallway, and then you go downstairs, and you go out. And is that to a street?
You go through if you can think about this as, let's say, as an apartment, okay? It sounds like it's like a 4-bedroom apartment. You have your living room, you have your kitchen, you have a bathroom. And down the hallway, in this apartment, you have 4 bedrooms. That's what it appears to be.
And you don't have to go, in order, there's no traversing, you don't have to go from one bedroom to another. Each bedroom is facing the hallway, and that's the access to it.
That's right.
So, Chief, let me ask you a question. If there was one family living there with 4 bedrooms in such a situation, then those bedrooms wouldn't need to have separate fire alarm systems? Or,
Well, if there was one, you said one family living in there?
yeah, then it'd be legal.
Well, I mean, whether the building requires sprinklers or not, sprinklers would be spaced, every 10 feet, they'd be spaced apart, square footage based on the requirement, NFPA 13, that's the standard for sprinklers. But with SROs, it's changing, the sprinkler heads have to be set up so that each sprinkler, you have to have at least one sprinkler head in the room. So it would have to be changed to meet that requirement.
I think that
This floor plan here is pretty informative with regards to the setup.
I wonder whether we ought to try to put this on the agenda at some point when we're talking about this. Because, I mean, I know Loft on Lawrence Street where my son lived, which had only one bathroom, one kitchen, and 6 spaces. And last year, my wife somehow somebody who's Persian cook. So we obviously went into the same building, and this young guy cooked a Persian meal for us. Once again, a series of bedrooms, a little common space, a kitchen, and maybe one bathroom, maybe two. And I just wondered whether we ought to try to address this.
Is that one of our lofts?
Huh?
Is that one of our lofts? Maybe try to use some?
No, it's not one of our lofts.
It's just,
It's just an illegal, it's an illegal residence zone where people are living there. Right? And I wondered whether we ought to try to address this and whether or not, three people, related by blood or marriage or whatever, but maybe we ought to try to discuss this and see if we can broaden that law, that if those single SR units could have separate fire sprinkler systems, maybe we can make such a situation legal, not us, but the state legislature. I just wondered whether we ought to discuss this. Because as far as I'm concerned, and as far as I know, there are many, many illegal law buildings where people are living in similar situations. So what would we rather have? Have them live in a dangerous situation, or have it legalized by some fire code, whatever?
well, in the instant case, I believe, first of all, that this is in a residential zone. Okay? And it can be legalized without the loft law, first of all. Second of all, in all of these situations, prior situations where we looked at eligibility, not fire safety, we looked at, this is about eligibility. Fire safety comes next. Whether we are saying that a loft with, here's the difference. If you had 3 of these units on the 2nd, 3rd, and 4th floor, it would not be a problem. Okay, we wouldn't be doing this. We wouldn't go through this analysis. Because we would have 3 units where there are people living independently. And in the situations where, like 10th Street, where you had a bunch of people living on one floor, it wasn't an issue for eligibility because they had 3 units. These people are saying this is a loft building because we have 1, 2, 3 loft units. Not a situation where one of the loft units has 3 roommates, and there are 2 more. We have many lofts that are configured like that. But we don't make that one space an IMD building. Because they are not living independently. Judge Addison said it in her opinion. They're roommates. These are not individual loft spaces. And in prior cases, they looked at, for individual use, they looked and they said, well, it's not so much the bathroom and the kitchens. If you look at all of those cases that she used, some of them had bathrooms but no kitchens. Some had no kitchens but had bathrooms. And those were really indicia of whether it had been converted to residential use. It was a separate inquiry as to whether they were independently lived in, occupied. And in the cases where somebody took his unit and subdivided it and put in little bedrooms, the answers were no. That doesn't consist of 2 or 3 loft units. That's 1 unit with 3 bedrooms. And this is what this is. 1 unit with ABC and actually a guest room, 4 bedrooms. Okay? And they're trying to shoehorn themselves into IMD coverage when I don't think that they belong.
No, certainly the way the law is now, they don't belong. But my question is whether we could try to get this law amended so that roommates can also constitute living in an into a law building. That's what I'm asking.
Roommates can be in a loft building, but there have to be 3 units, not this kind of configuration.
All right. I understand this is 1 floor. What I'm thinking of is that there are buildings of 4, 5, and 6 floors where there are units like this, and so far as I know, none of those buildings have come before us.
That's their choice. They have.
I understand, but it's their choice, they're living illegal.
So,
we're condoning illegal loft living in the city of New York because it's beyond our jurisdiction. That's what I'm asking.
Mr.
Maybe we
Barrett,
should do
in the
something.
old days, in the old days, what did we do? We went out and we said, you are loft buildings. We're registering you, right, Mr. Delaney? Isn't that what we do?
Sometimes.
Right. So we know, but we don't do that now. So we have this window period, the people didn't come in. We did not have the will or ability or something to go out and bring them in ourselves. We have, I think, the will to want to open up the window period so that those people who are living illegally can come in and become IMDs. I'm not sure that that the Department of Buildings would find a flaw with your logic, because we all believe that we want to know where these people are living illegally, and we want to bring those buildings up to the building code and make them safe. There's no question that that's what we want to do. That's what we're here for. That's our mission. But it's up to the legislature to permit that.
Just going back to your summary of Judge Addison. However, Judge Addison reached the conclusion
Right.
that these were three
But
independent.
she relied on, I think she was sort of leaning towards that. Then she found that she was faced with these cases that and she was really sort of trying to figure out what to do with the bathroom and kitchen problem. So she pulled out these cases, which all talked about bathrooms and kitchens, but what she failed to really, it appears to me, to really understand or to realize was that those cases all talked about residential use and not about independent living. She never really goes through that with the analysis that it should have had with regard to independent living. Were they living independently, occupying independently from another? Had she done that, I think she would have come out the other way. I think that it's fairly clear to anybody who looks at the floor plan what this is. So we're going to move on.
I certainly can't fault it. Let's say hypothetically, a little skinny building on 7th Street there, and there was the same situation, except they were vertical. And years ago, when these tenement buildings in New York, there was one bathroom per floor, or something like that. Could we construe that if they were living like this independently, with one kitchen and bathroom upstairs, that would still be illegal as far as we're concerned?
Can we just say that we're not looking at the bathrooms and the kitchen? When we look at the analysis, that plays one part of it. That's one factor. So maybe, and as I said, sometimes there's one bathroom that's being shared by multiple floors, and those are in these cases, and they've been found to be IMDs. But they were individual spaces.
What I'm saying is, if the spaces are stacked
Yeah.
vertically and horizontally, that could then be legal. But since they're not stacked horizontally, it's not.
Because
That's what we're saying.
why would that be? Because they have their public hallway, right? They're not sharing the common area. They have their own discrete occupied space. And they usually, in these cases, if they don't have the bathroom, they have the kitchen. I mean, they have indicia of residential use in the unit, and because they're on separate floors, they have that indicia of independent occupancy. In this case, you don't have that. Anybody else?
Okay, is there a motion to accept this case? Sheldon, Mr. Shackleton as well, so we have the first.
Mr. Barrett,
Yes.
Chief,
Yes.
Chairperson Bishop,
Yes.
Mr. Delaney,
No.
Mrs. Hackler.
Yes.
Shelton.
Yes.
5 in favor, 1 against, 1 absent.
Thank you. Passes. This will conclude our June 18th, 2015 Loft Board public meeting. Our next public meeting will be at Spector Hall, 22 Reed Street, first floor, on July 16th, 2015 at 2 p.m. I thank everybody for accommodating